Next slide. All right, as mentioned, today's session is going to focus on drug user health policy, advocacy, and advocacy priorities in Tennessee. Next slide. To sort of kind of set the landscape of today's call, there has been tons of policies that have been introduced this legislative session, ranging on tons of different topics from LGBT health, immigrant rights, and more. Reproductive health care. For the purpose of this call, we're really going to be focusing in on policies that impact people who use drugs, the organizations that serve people who use drugs, and criminal penalties that relate to drug use. Next slide. Our speaker today is going to be one of our very own subject matter experts, Elliot Pensley. Elliot Pensley serves as the Chief Executive Officer of the Behavioral Health Foundation, a policy research center focused on mental health and addiction. Elliot has received numerous awards at national and state levels for his leadership in mental health and drug policy advocacy initiatives. Next slide. Without further ado, I will turn it over to our speaker.
Thank you, Amber, and hope everybody's having a good day today. I appreciate that very kind introduction. So today we're going to be talking about my favorite professional subject, which is legislation. It's not always my favorite just because of how difficult advocacy and policy analysis and engaging with lawmakers to explain unintended consequences and things like that, or trying to, encourage positive policies that help people sometimes is a lot more difficult than you might think or hope it would be, but it is definitely not fruitless. I'll start out by saying people like myself, who I am now a policy expert, but didn't used to be, and before I was, just figured out how to write a proposal for things that were important and could be good, and putting those words on paper and finding the right avenue, in this case, Department of Mental Health Planning and Policy Council process, was able to get multiple proposals to become state law and become bills that were supported by the administration and the governor. Legal decriminalizing fentanyl test strips, for example, a modest but at least important expansion of the Good Samaritan law, not as far as we wanted, but these were all done because I put words on paper, talked to folks, and then put it in the right hands to make sure these things could get done. So every single person here has the ability to put their ideas or thoughts into motion, whether you do it directly or working with someone like myself or others. I'm sorry, it looks like I'm freezing. Apologies if my computer is freezing. I'm going to close the tab here. Next slide, please. That's a little bit more about the Behavioral Health Foundation. I engage with lawmakers. We have volunteers, we have interns. We do as much work as we can at state level policy. Tennessee is our primary focus area, but we do work in other states as well. So instead of federal level policy, which is important, we focus on state level policy primarily because that is what impacts people at the end of the day the most. In terms of policies that happen at the state level are going to impact people who use drugs, people that serve those who use drugs, people with substance use disorder. State policies are going to have the most direct impact. They also, the state level, often translate the funding that may come from the federal level into how it actually is delivered in terms of services and directly to people on the ground. Next slide, please. Well, I care about policy. You're on this call, so that's a good start. I know not a lot of people here really feel comfortable with understanding what's out there right now in terms of state legislative policy, but it's really important to understand. These policies at state levels absolutely shape the environment that you all work in and that drug users live in. They can impact people directly. They can impact providers directly. Sometimes they can really do good things. Sometimes they can backfire and cause harm or unintended consequences. So we're going to focus today on really I worked with Amber and other subject matter experts to go through the legislation to find what are the most important bills currently filed in Tennessee that are likely to or already are or may get debated this session that you all should be aware of. Next slide, please. Okay, we're going to start about one that when I first saw it took me aback a little bit. I don't know if anybody remembers a bill that was called Brittany's Law from 2 years ago. I was very involved with that, but that was a bill that would have made it a Class B misdemeanor if someone sees a person who they know or reasonably should know is overdosing and does not call 911 or render aid. And that bill did not pass. It failed in criminal justice subcommittee. I, along with a colleague, gave testimony, and this coming back basically was like, okay, we're seeing the same type of thing again. So I actually met with Senator Lowe yesterday. I'll hold that for a second. So I have more of the story with this one. But when you read this bill, this is actual language from the bill. I may have paraphrased something small, but this is mostly true language from the bill. So this is basically saying we have a new charge for criminally negligent homicide that's going to be a Class E felony. And what would be considered enough to be charged with such a felony is if you fail or refuse to render aid to another person, if you know or reasonably should know that that person is unconscious or they need medical care or aid, and you should know or reasonably should know that the reason that they are unconscious or need medical attention is because they took some sort of controlled substance. So that is the bill. That is what this is doing. It's very similar to Brittany's Law with more severe penalties. And frankly, it's much broader in nature. It doesn't define what rendering aid means. It does say instead of overdose, it does talk about controlled substances. So this would not apply to situations regarding alcohol, for example, or non-controlled substances. But most overdoses other overdoses are related to controlled substances. So this is the opposite direction of the Good Samaritan Law, the complete polar opposite direction. And as I told lawmakers in 2024, if we were to pass something like this, Tennessee would become the first state to have what a quote unquote bad Samaritan law. And fear is really what drives a lot of people not to call 911, not to remain on the scene. Reducing fear is what evidence shows is most helpful in encouraging people to call 911 and to help and not to leave or run away. So that's why states have moved toward Good Samaritan laws. Now, we have a relatively strong Good Samaritan law in place in Tennessee. However, it has major holes in it. One of those is a one-time overdose limit, where exception for the person overdosing. Now, the proposal I mentioned a moment ago that I wrote, we did try to get rid of that, and we'll talk in just a second about an effort to fully get rid of it. But it was amended a couple of years ago during that process to where now local law enforcement and district attorneys can offer immunity at second and subsequent overdoses at their discretion. But to my knowledge, not a single DA or police or sheriff's department in the state has put into policy saying they will not arrest or charge people in these circumstances, even though we know in certain urban areas, especially, Nashville is one example, this is a unwritten policy that they don't charge people at second and subsequent overdoses, and they did so. That was the case even before that other bill I mentioned. So this is going in a completely different direction, and there is no evidence that we can find that would suggest that this would improve things in terms of preventing overdose deaths. And there is some evidence to suggest that it might actually have the unintended consequences of increasing overdose deaths, despite its intent clearly being about reducing overdose deaths. So the reason for that is if even a small percentage of people were to run away from a situation because they are scared they could be charged with criminally negligent homicide, and they take off when otherwise they might have stuck around or helped or tried calling 911, that could lead to an increase in overdoses that could outweigh any potential benefits of this. There just really is no evidence that I can find that I'm aware of that suggests that this would be a positive policy. Although there is I do understand how people who lose family members in situations where their family member died, they overdosed on um, drugs or alcohol, and someone else was there who they believe could have helped or intervened. Or sometimes people leave on purpose or are just dumping bodies. We've heard of these things happen. It happens. And these folks want accountability. They feel like someone wronged my child, someone wronged the person I love, and I want someone to be held accountable. Doing so is challenging in many circumstances and may be against the best interests of the state in general, depending on how we go about this. So I'm going to back up for a second and just explain the conversation I had with Senator Lowe yesterday. It went better than I frankly expected. Senator Lowe is someone who sponsored a bill that expanded drug-induced homicide laws in Tennessee. He has typically taken a pretty hard-line approach on these type of subjects. He explained that this bill came from his local district attorney, General Hatchett. I actually have a call into his office to talk and get some more information about the situation. So I don't have full details, but here's what I know. A constituent in Senator Lowe's district recently died due to overdose in a unusual circumstance, at least unusual based on what I've heard before. There was a boyfriend there, reportedly using drugs with his girlfriend, the person who died. And this person's mother was apparently upstairs. I don't know if they're in a basement, some lower room in the house, something like that. And I was told I was allowed to share the story, by the way, and I'm not going to provide any names. But the mother upstairs was a nurse and potentially could have helped, and that's a factor in this circumstance. And here's what I was told. Again, I can only go based on what I was told. Is that the girlfriend, the woman, she started to overdose, and the boyfriend did not make any effort to render any kind of aid, did not call 911, did not go upstairs to ask for help from the nurse, the mother who was upstairs. And in fact, or at least as I was told, actually went and turned the air conditioning down in an attempt to increase the likelihood that the girlfriend were to die from the overdose. Again, this is just based on a report. And the district attorney in that district has been working with the family who is wanting accountability for what is seen as a cruel action here, allowing someone to die and potentially even aiding in that death. And this was the solution that was put forward by the district attorney. And I explained to Senator Lowe how, while I understand that that is certainly a tragic circumstance, and it sounds like a situation where if someone truly was trying to create conditions or intentionally wanted someone to die, that certainly is something that is worthy of trying to address. However, this bill goes way beyond that circumstance and would have many unintended consequences. And frankly, he seemed to understand that. And what he explained to me is that he had to put this bill on notice because everything is moving very fast right now in the General Assembly. A lot of committee calendars are already going to final calendars where everybody has to put their bills on notice. He's not certain if he is going to run this bill this year or will wait and try it again next year. And he is open to adjusting the language to narrow it in a way that would more appropriately tie to that situation. So that is what I will be working on in collaboration with Senator Lowe's office and General Hatchett to try to find a way to solve the situation that they're looking at in their district while not causing unintended consequences more broadly for people who use drugs and people who encounter people who use drugs. So very complicated issue. We will be watching carefully. I told Senator Lowe that if this does get heard in committee, I will be signing up for testimony neutrally just to talk about the issues involved here, and I will be meeting with committee members. But it's not clear if this is going to be heard or amended this year, but we will keep watching. So sorry for that long explanation, but I thought it might be helpful. I would be very open to any questions or thoughts on this.
So you are welcome to raise your hand and unmute. You can also put questions in the chat, or if you want to ask a question anonymously or leave a concern or comment, you can do so in the Menti as well.
I will defer to you all to advance when you're ready.
I'll give it 10 more seconds to see if anyone has a question. If not, we'll keep rolling because there's a number of policies and we'll have little stop points throughout. So if a question about this bill comes up later, there'll be more opportunities to ask.
And I welcome people to reach out directly to me afterwards. If you have a difference of thought on something that I say, if you have ideas, there's a bill that you're interested in or have questions about that I don't talk about, or you have follow-ups, please reach out to me. Text or phone is the best. And I can share, or someone can share my cell number in there, or I can do so later. That would be great.
We do have your number, and I'm sure Anastasia is actively pulling it out of our document, and we can share that in the chat.
Amazing.
All right, we'll move to the next policy.
Okay, this is that related Good Samaritan bill. I helped with this. This was the exact bill, basically. What you're seeing is not language. It's a summary that I wrote for another purpose. But this is the exact language that I had in this bill that I had put forward in the proposal through the Department of Mental Health Planning and Policy Council. It became administrative bill, just another effort to try and remove the one-time overdose limit fully. Unfortunately, it does not seem like the sponsors are going to move forward with this legislation due to strong law enforcement opposition to the bill. The police and sheriffs are opposed. The TBI is likely opposed. They have said they are, but they haven't taken any official position because it hasn't been put on notice yet. And we expect the district attorneys likely will be opposed to this as well. Representative Helton Haynes, and what you'll see throughout are underlines under one of the two sponsor names for each bill. It is not a perfect science, but where I know for sure, or where I am guessing or using educated guessing, is the lead sponsor is in underline. So when you see that, it's usually going to be someone. You have to have a House sponsor and a Senate sponsor for every bill. You have to have the same bill filed in both chambers and has to pass in the same form for it to become law at the end of the process. But usually there is one sponsor who is more in the lead, the one who brought the idea to the table. Sometimes it's collaborative and they both came at the same time, but more often it's one driving and the other agrees to carry it as well. So Representative Helton Haynes has had this, and she still feels very strongly about this bill. She knows it would be very helpful. She knows it's very important. She is concerned that she will not be able to get it passed through the House Judiciary Committee, given the law enforcement opposition. And they haven't budged in the conversation she has had with law enforcement so far. And so she basically said, if you want to find somebody or you're able to find someone who's on the Judiciary Committee who can carry this, I'd be happy to hand it over and still will help and, of course, vote for it and support it. But by the time that all came to play, it was very late in the process after the bill filing deadline, and trying to find someone in a position to carry this is an uphill battle, to say the least. So I'm very sad to say that this is not going to move forward this year, but it's still something very important that I hope will move forward in the near future. Next slide, or we can have questions on this.
We'll take space. If anyone has questions, you can put it in the Menti or comments or ideas. Yeah, Brad, it looks like your hand might be up.
What do you exactly mean by immunity? Is that like for like somebody has a warrant, or is that for like potential charges with like what they're carrying on their persons, or does that include everything?
Great question. It's limited immunity, and it's specific to a few things. So the key immunity protections, and this is in the existing law, that it applies to bystanders, who people who call, and then also for people who are overdosing, at least on the first time and potentially on second and subsequent times, for simple possession of drugs, for simple controlled substance, I should say, for casual exchange of controlled substances, or for possession of drug paraphernalia. It also provides immunity it's not quite the same as the other type of immunity, but it provides protections from probation and parole violations and other warrant type of issues. but law enforcement are still able to investigate and ask and look for any other potential violations. So if they can justify that someone is selling or distributing drugs, then they can still charge you with that. If there are other offenses ongoing, they can still charge you. But it is pretty strong protections for possession of drugs or drug paraphernalia. One hole I didn't mention earlier, I mentioned the one-time limit, is the drug-induced homicide law. And once those laws were put into place, which were after the Good Samaritan law first went into effect in Tennessee, we see ourselves in a situation where bystanders are sometimes darned if they do, darned if they don't. So even if a bystander were to stay and do everything possible, when I say bystander, it could be someone who is using drugs with a friend or a loved one. If they were the person who supplied the substances, doesn't necessarily mean they sold or dealt the substances. They might have just been the one to bring in the pipe, the syringe, the powder, whatever it may be, and use with others. And someone overdoses unexpectedly. They give compassionate overdose response. They administer naloxone. They call 911. They do everything the 911 operator says. They stick around, rescue breathing, the whole 9 yards. And sadly and tragically, that person still ends up dying. They absolutely can be charged with second-degree murder or a drug charge that carries the same sentencing penalties. And in fact, those exact type of charges and prosecutions are indeed happening in Tennessee. So that is a something to be aware of. And this is why we are very concerned with the fact that while we have an otherwise strong Good Samaritan law in terms of its backbone, in practice, it's incredibly difficult to educate people about this because of all the ifs, ands, or buts about it. So educating and making people aware of immunity protections is critical for this to be an effective policy. And right now it is challenging. We should still make people aware, but you have to be careful. We don't want to mislead people into situations where they no longer will trust reaching out for help. Good question. I hope I answered it.
Any other questions? All right, we'll move on to the next policy. Again, if questions come to mind, feel free to put them in the chat.
Seeing a familiar name here with Senator Lowe and Representative Zachary. This is a bill that was filed last year. I took out the leading zeros just for readability here, but you usually see a 4-digit bill number. So if you're wondering about that, you usually can type it in either way on the General Assembly website. You can type in SB 120 or SB 0120, and it should take you to the same place. If it doesn't, just add that leading zero. But this is a bill from last year. There's no sign that it's going to move this year. I haven't seen it put on notice yet, although I didn't check today, to be fair. And these calendars are closing soon. So we'll be looking to see if this goes on notice within the next weeks. But we wanted to mention this just because of, this is something that has come up in various ways in the past several years in terms of legislation in Tennessee and would have potential consequences, and also does relate to some mythology around fentanyl. So this bill is about aggravated assault against a first responder. If someone is knowingly possessing fentanyl or a related substance in a way that would expose a first responder. Now, this bill specifically says that exposure must actually happen. It can't just be in someone's possession, as we've seen in other legislative attempts. They have to be direct contact. It says right here at the bottom, by touch, ingestion, or inhalation. So that would be the first responder. And that has to result in serious bodily injury or death. So those factors actually represent a significant positive step, if you will, compared to past versions of this bill we have seen in recent years that have not required the serious bodily injury or death, and that could have resulted in literal exposure or being near fentanyl, causing significant criminal penalties. We know that there's a lot of first responders who do end up, I shouldn't say a lot, there are some first responders that do end up getting treatment and going to the hospital and believe that they have been exposed to fentanyl and experience an overdose situation. What we also know is that in many of those cases, that the person had a panic attack instead of an actual overdose. And some of those symptoms can mimic what we see in certain overdoses in terms of passing out, those kinds of things. Not directly, it's not the same. But then when they get naloxone and wake up or calm down, they think it was the naloxone that reversed an overdose, when really it's just their anxiety is being soothed and reducing. So you can get overdosed by fentanyl if you expose it to mucous membranes. You rub it into a cut that's on your skin that's open. There are ways, but touching fentanyl is not going to cause an overdose. And there's a lot of mythology around that. So this bill is there. We don't know if it's going to proceed. It's a Class C felony. And I just wanted to explain kind of how this is actually somewhat of an improvement from what we've seen before, if it does end up moving forward.
You want to go to the next slide, Allie? Does anyone have any questions about the fentanyl assault bill, this version or the previous versions that we've seen? Okay, we'll keep rocking and rolling. Next slide.
Okay, interesting bill. Senate Bill 1039, House Bill 1102. This is about prenatal and postpartum testing, drug testing, and adding a consent requirement. So basically, this bill is about making sure people who are pregnant or just had a baby and the newborn themselves, that this person is able to say no to a drug test if they are offered one. A lot of times this is routine. It can lead to DCS investigations and potentially even law enforcement investigations. We used to have laws that required people being charged with fetal assault in circumstances when drug use was involved. So this is something that is truly important for people in healthcare situations. And this does allow for the testing to be done in emergency situations where any delay could cause harm to the adult or the baby or newborn. And this would be something done where only when necessary, the way the bill's written, and they'd be required to provide documentation saying that there are risks involved with the testing. So, I mean, they might do it, but they're going to warn them that they could see investigations if certain things come up positive, other things like that. This, though, really does change the game if this were to pass in terms of giving people the right to say, I don't want that in most circumstances. So that's what this bill does. It is unclear to me what the chances of this bill passing are. There was a sponsor change in the House from last year. Representative Salinas had it. And frankly, she's a very progressive Democrat, and she's not someone that's likely to pass a bill of this nature. And so the organization who's been advocating for this is found a Republican sponsor to take over the bill, and they will be seeing if they can get it done. So that's what this one does. Next slide.
Any questions, comments about that bill? And I believe I mentioned this. If you want to read any of these bills or see where they're at, we're providing links in the chat, and we'll also have all the links coalesced in the Echo platform after this session.
I can't type fast enough. Question about this one. When you're seeing pregnant or recently postpartum individuals in your clinic, if you have like an OBOT and we have state requirements on the type of screening we have to do, how would that fit in with something like that?
That would likely override them. I'd have to look back at the language of the bill itself. If you can give me just a split second. Amber or someone, can you tell me what's that? Oh, I see it. SB 1039. I just want to look at the language very quickly. I'll try to do this in real time to make sure I'm seeing this correctly. And you can do the same. It's a 4-page bill. So I'm trying to look, but I'm trying to see if there's any language that talks about existing law. This is about healthcare facilities licensed under Title 68, Chapter 11. I am not 100% what all falls under that, but if your facility or an OBOT would fall under Title 68, Chapter 11, then it would be applicable. And it would essentially override whatever might be in state rules or regulations and require changing those.
Okay.
Great question. Sorry, I can't answer it directly, but that should give you what you need to answer it. And we can follow up later if you want me to.
Next slide, Allie.
Great. So this one is really important. This is about parental rights of children, and it does stem from a bunch of other related efforts to give parents more control over healthcare and other decisions related to their children, and concerns among many in the majority about gender affirming care and such. However, this is not limited to gender affirming care or anything like that. This bill, Senator Pody has been trying for the last several years to get legislation passed that would remove the right for 16 and 17-year-olds in Tennessee to access mental health treatment, which would include substance use treatment, without parental consent if there is a significant need for it. Like, as long as there can be a documented diagnosis or symptoms that would suggest a diagnosis may be needed, then there's a mature minor doctrine in Tennessee that allows 16 and 17-year-olds to access their own mental health care services and addiction treatment. So in this context, this bill is trying to would give parents the right to access literally all records involved in not just medical treatment on the physical healthcare side, but also mental health or substance use treatment. And so it would essentially remove the right currently that 16 and 17-year-olds have under present state law to the same privacy rights that adults have in those situations. A couple years ago, there was legislation that did give parents the right to access prescription records for 16 and 17-year-olds who are seeking treatment without parental consent. To me, frankly, I feel that's a little bit of a different issue because there may be legitimate situations where parents need to know what prescription medications their child is taking, especially if there is an emergency, a car accident, something else, the child needs treatment. And if the doctor's hospital not aware of everything that that person may be taking, it could be problematic. But that said, this goes further and would allow therapy notes and such to be provided. Now, it would require a parent knowing where their child is getting therapy or counseling, which if the child is going without parental consent, they're probably not telling them. But a lot of times this can be done at a school, so it may not be difficult, or there may not be many clinics in an area. So it may not be too challenging for a parent to find out where they're going. But if this were to pass, they would be able to get those records. There's a very narrow exception, and it's only if there's a DCS report being made. And as part of that, then there have to be fears that releasing the records can endanger the life. But without a report being made, as I'm reading this, you can't just use the argument that releasing could be jeopardizing the safety of that patient. The bill also touches on a kind of an error that or going too far, if you will, that the Families' Rights and Responsibilities Act from 2 years ago, I believe, how far that went, in that it basically handcuffs school districts. If they didn't get back consent forms from parents, then they couldn't even do basic first aid when a child got hurt at school, and it caused all sorts of chaos. I am actually not 100% sure if that was or was not addressed in other legislation last year. This bill is a carryover from last year, but that's why you see this here. That's a cleanup part. That part makes sense. The rest of it is concerning and could lead to a chilling effect in terms of 16 and 17-year-olds seeking treatment in Tennessee. So next slide.
Any questions, comments, concerns? The Menti's open. You can put them in the chat or you can raise your hand.
And if you see something in the Menti that comes in later, we can always go back. I would say let's keep going.
All right, next slide.
Freedom bills. There are 3. Only one you really need to be aware of, and it's the one at the top. I'll start by talking about the one on the bottom left. That one is a regulatory framework. So this was about making sure kratom was not going to be completely illegal, wasn't going to be broadly criminalized for possession. There would be issues related to minors possessing. And usually that means under 21, not 18 in the context of drugs and controlled substances. But that bill did not make it out of Senate's delayed bills. I was told it was filed on time, but I cannot verify, but I confirmed with Representative Towns' office yesterday that the Senate is not going to allow the bill to proceed. So it is, unless something changes, I'm told it is dead in the water for procedural reasons. The other one at the bottom was an alternate version of the bill that you see at the top that's advancing, and it was far more strict. And I'll just say, thank goodness they decided not to go with that one. The bill that is advancing is called Matthew Davenport's Law. It's based on a constituent of Representative Helton Haynes, whose family states that kratom is what caused their child to die. And this creates a Class A misdemeanor for possession. That's the highest class of misdemeanor. It also creates a Class C felony for manufacturing, delivering, or selling kratom, and that goes up to a Class B felony if it's sold or delivered to a minor. The difference in the other bill was going to be felony possession charges, which is extreme by any means. I mean, I was shocked to even see that written, frankly. A Class D felony for simple possession would have been, I don't know if it's unprecedented, but it would be fairly unprecedented, at least in terms of how we do things in state law otherwise. Especially for a substance that is a naturally grown substance. And then it would have been a Class B felony for selling or manufacturing, and Class A if sold to a minor. I mean, those are extreme by any way you look at it. But the bill that's moving forward, and both of these have these same requirements, there's also some interesting components beyond the criminalizing of possession and selling. So this is a full kratom ban, all forms. It requires that medical examiners, when they do autopsies, that they check for kratom. They're looking to see if kratom's involved in more overdose deaths. And it also requires any physician who's ordering some type of lab test to test for presence of drugs when they suspect someone has experienced an overdose, or that there's a situation that might involve neonatal abstinence syndrome, that there now would be required to test for kratom, which I thought might cause some issues for the healthcare community, but I'm not sure how strongly those concerns have been raised yet or if they will be. But there is a lot of momentum. It passed its first step yesterday overwhelmingly in the House, and this bill is on track to likely pass. I can't say for sure what will happen. I know, of course, the people that advocate on behalf of kratom are, very much opposed to this legislation. But Representative Helton Haynes has been working on this for a couple of years. She had a resolution about it, and there's a family story to go along with it. And so it looks like kratom next year or later this year is likely going to be illegal to possess or sell in all forms. Next slide.
Questions, comments, concerns? Menti's open. We've got the chat box. You can also raise your hand or unmute. Okay, we'll keep
All right, next
rock
slide.
and
Again, we can always go back. Okay, there are 4 nitrous oxide bills. 4. I'm glad they all coordinate. I'm just kidding. But some of these legislators are even laughing at themselves about some of these. But the one on the left is the only one that we should worry about. I confirmed with the sponsors on the House side and one on the Senate for all 3 on the right that they are not planning to run these bills, that they are all deferring to the bill that is being led by Representative Ashley. And they're calling it the Nitrous Oxide Abuse Prevention and Retail Sale Prohibition Act. It bans selling it at any retail store for the purposes that might be used by people to get high or use recreationally. It's not, there are limitations in there to make sure this doesn't ban the ability to sell cans of whipped cream and such, or for dentists to do this. This is about retail sale. And it does make it a Class C felony to sell nitrous oxide if it can be proven that the retailer or the person that sells it is selling it for the purposes of someone to use it recreationally. So that's what this does. Frankly, it's better than the bottom two on the right if you're concerned about criminal penalties for possession, because it does not have those involved in the bill. It is about banning the sale, which, as far as evidence-based policy goes, is a better way to go about starting to look at addressing substances that are concerning in communities than going to outright full bans and criminalizing possession, knowing that often when you just jump to criminalize possession, people end up in jail and prison, and that is not always the best thing for people unless you are an investor in Core Civic. Next slide. Oh, and two of the other bills related to poppers or amyl nitrate, but the current bill that's advancing is strictly limited to nitrous oxide, if I'm not mistaken. Next slide. This is a really important bill. I was really surprised to see it, frankly, but I'm very happy about it. It was one I was planning to write into a legislative proposal for this year's Planning and Policy Council process. What this bill does, Chairman Faison is leading. I met with his office yesterday, and it passed its first step very easily, to my surprise, frankly. Right now, in the bill, you'll see, I think it's non-substitution based non-residential treatment center, something like that. But there's language that's used. But what that's referring to is opioid treatment programs, which are known as OTPs, or otherwise known as licensed methadone clinics, that are overseen by the Department of Mental Health. And so methadone, in the evidence we have available, is the most effective evidence-based treatment we have in our toolbox for the treatment of opioid use disorder, followed by treatment via, medication assisted treatment, MOUD, for with buprenorphine products. But methadone consistently shows even stronger reduction of overdose risk. So this removes an often burdensome process called the certificate of need, which is required by hospitals, for example, to open new hospital facilities in communities. It requires a lot of paperwork, fees, a lot of community work to make sure you have buy-in from local communities. And we know that local communities in recent years have actively worked to block methadone clinics from opening, even though we know there is a major disparity in terms of access to licensed methadone clinics in many rural areas of the state, especially. This would open the door for more methadone clinics to be made available to people in Tennessee. It could open the door to mobile methadone, which right now is not allowed, because even if you have a certificate of need, you'd have to get one for every single location you set up for on any given moment, at any given day or any moment. And that's just not possible. Also would open the door for a newer type of innovation. We've seen there's some secure telehealth kiosks that are being used in some other states. This is something that Chairman Faison was particularly interested in. These are, staffed, secure places where someone can go and basically get take-home doses without having to access a full-scale clinic. So this really opens the door to better access to methadone. So this one is moving, and we'll see what happens. Next slide.
Questions, comments, concerns?
I would say let's just keep going, and just
Yeah.
if you get something, someone have them please go in there and do that, and then we can go back to it. Two buprenorphine bills. Suboxone is, if people don't know what buprenorphine means, Suboxone is often used synonymously, even though it is a specific brand name combination product that also has naloxone in it. There's two bills. The one on the right is basically fixing just something they missed in legislation from last year that allowed psychiatric nurse practitioners and physician's assistants to prescribe buprenorphine products in jails and prisons. They mentioned employees and contractors, but forgot to mention subcontractors, which is a problem for them. So this is just adding subcontractors to make sure that that law can be used to its full extent in jails and prisons. And I've been having great conversations with the person overseeing the MOUD program in prisons in Tennessee. I can tell you they are seeing fantastic results even with a relatively small rollout of that program. So any expansion is positive. On the left, it relates specifically to community mental health centers and federally qualified health centers only. Frankly, I wish this was more broad, but this is how they decided to present this. It came from special, a particular side. The community mental health centers brought this bill through their lobbying organization, TAMHO. And it's a very positive step. But right now, psych nurse practitioners and PAs, even though it's limited how they can treat people in those settings with patient limits and such, they are not able to prescribe long-acting injectables like Sublocade and Brixadi, which many people are interested in. So this would allow them to do that. And it also expands the allowance for those mid-level providers in terms of providing monobuprenorphine, that would be buprenorphine without naloxone, not just to people who are pregnant or have documented allergies, but also to nursing mothers. Next slide. There are 3 bills that are identical. There's like there might be a slight text difference between 1 or 2 of them, but they literally are identical otherwise. This expands a law that already passed. Right now, there are 2 categories of this escalated assault charges where there are mandatory minimums and fines. The fines are particularly scary to me, but this is already law. Right now, nurses and first responders are categorized together. So it would be a $5,000 minimum fine and a 30-day minimum sentence. But what these bills all do, and it looks like the one at the top left is the one advancing. The one on the top right also is scheduled, but unclear if it's going to advance. Only one of them really can become law if it does. So the first responders are now being moved up in the same category as law enforcement, bumping it up to a $10,000 minimum fine and a minimum of 60 days in jail. But frankly, the 60 days in jail is sort of a joke. It does remove some discretion, but for a Class C felony, people typically serve more than a half year in jail if convicted on those charges. So this has significant implications for people who use drugs. This could come into play when there is an accidental needle stick, for example, right? This could come into play where someone, law enforcement, or in this case, it would not be law enforcement, it would be first responders, EMS, or firefighters who are present, who are helping to reverse an overdose, administering naloxone. And if a person comes to and is disoriented and flails and strikes someone, they could potentially be charged with this. Those are just some examples, but this does have potential implications for people who use drugs. Next slide. Okay, recovery housing. This is a bill that is similar to one from last year that originally was focused statewide, but ended up being limited to Hamilton County. That's the Chattanooga area. And the thought behind those who were advocating to limit it was that Hamilton County wasn't actually planning to do this. However, now we see another county coming in, Putnam County. Representative Williams is leading, as I understand. They saw that out there as a pilot that was offered to Hamilton County if the local government decided to do it, to regulate recovery housing. And they said, we want to do this too. And so this bill specifically adds Putnam County to that authorization to do this local regulation of sober living homes, or otherwise known as recovery housing. This is extremely NIMBY, not in my backyard. This is basically got distance requirements. It has other abilities for local governments to basically say where a recovery home can and cannot be. And this is the most concerning to me, is that it would require a recommendation referral from a licensed healthcare provider or court for someone to access recovery housing. And not all people access recovery housing through those routes. So this is something that we knew was concerning last year. But now we're seeing others trying to get in. And while I have not confirmed, my guess would be that if Putnam County specifically, their representatives are wanting to do this, that there likely is some intent or hope that local governments there, either in Cookeville or the county at large, will implement this if it passes. It does say it must comply with Fair Housing Act or ADA, so that does limit it to some degree, but unclear how much. Next slide. Is that the end of the bills? We made it. But happy to answer questions about any of these or anything else I didn't mention in the remaining time.
Allie, can you go to the next slide?
Oh,
So
yeah,
we should
sorry.
Yep. And then after we do this slide, we're going to turn off the recording and we'll have an open Menti for any questions with the recording off. And then also people can unmute and ask questions about any of these bills or policy in general.
Thank you, Amber. Sorry, I forgot about this slide. But yes, I won't talk too much about this. You can read it. But there are so many ways to get involved. Like one way is literally just contact someone like me or your supervisor or colleagues about things you see in your community or legislatively or in the news or anything you see that is worth talking about, looking at solutions or guarding against consequences or unintended consequences. Read, follow bills, look at the General Assembly website. We provided tons of links throughout this presentation. And there's one here. I don't know if it's easy to put it in the chat, but you can also go to the General Assembly's website, capitol.tn.gov, and then there's a button toward the top right, usually for My Bills. And you can actually follow the bills that are most important to you right there. You have to create an account, but it's free, it's easy. And then you can just add any bills you want, an easy place to track status of, and go there. Get involved in a coalition. If you want to get involved in advocacy directly, contact your legislator. Don't just contact them, know them. Work on developing a relationship. Try to get their cell phone number so that you can text them if you're not in their area, not able to often come down to the Cordell Hill building during session. If you want to get engaged with legislators but are scared to do so, you don't feel like it's your place, you feel like it's just a big, bad, scary place, or they won't care about what you say, you're wrong. I thought that too. It just takes trying it. And I'm happy to, for people who are interested, if you ever want to shadow with me, just reach out. Happy to do that. So lots of ways to get engaged. Please speak up in some way or fashion. Please reach out. I need eyes and ears. We all do. Please let me know what problems you're seeing, what thoughts you have, and ways we can help support you in terms of advocacy. Thank you. And yeah, just a little bit more about us.
All right.
So any
Allie,
questions?
we will stop the recording.